Next case is People versus Kavanagh. Please proceed.
Thank you. Good morning. May it please the court, Aaron Mead from the Berrien County Prosecutor's Office representing the people. I believe there are at least 5 reasons why the standard of review where findings of fact are based on, in whole or in part, on recorded evidence such as video recordings should remain clearly erroneous. The first, as has been pointed out in more detail in the amicus brief from Pam, is that the language of MCR 2.613C simply doesn't make any exception for any particular kind of evidence. The first sentence is not dependent on the second. It says straight out that findings of fact are to be reviewed for clear error in all cases, essentially. Secondly, the purpose of the clear error standard isn't limited to credibility determinations, and that was discussed pretty thoroughly by the United States Supreme Court in Anderson v. Bessemer City and by the Supreme Court of New Jersey in State versus SS. There are a number of those laid out there. The trial courts, for example, are the primary fact finders, and they have expertise based on experience in making those determinations. The cost of duplicating the same work in appellate courts and multiplying appeals, the lack of stability that the public has an interest in having questions resolved once and for all, and even undermining the legitimacy of lower courts in the eyes of the litigants, who then would just see, well, who cares what the trial court finds? It's going to go up anyway because it's essentially de novo, and so we're never going to be done with this until we get to the top court. The third reason is that despite the way that some courts have characterized it, or that the amicus from CDAM characterizes it, video evidence is subject to interpretation. It can yield contrary factual findings among reasonable people. There are a number of those cases that I've discussed in the briefing. I was reminded when I thought about it of the fact that a few years ago the internet graced us with a dress that divided the world on whether it was blue or gold, and nobody could agree on that, even though they're all looking at the same thing. And more recently gave us an audio recording where no one could agree whether someone was saying Laurel or Yanni. Video and audio evidence is interpretable, and therefore we defer to the trial court as we do in all factual finding situations. The fourth is that the questions that trial courts and appellate courts are typically asked to resolve are much different from the kinds of questions for which video is really at its best, as CDAM is kind of arguing for this instant replay rule as in the NFL. While obviously there's a huge difference in the quality of the video and the number of cameras. I think there were something like 70 cameras used to film Super Bowl 16, and they're much better than the ones that we're ever going to see in a squad car. But also, we're being asked to decide things like what did the officer reasonably perceive? Did the defendant appear nervous? We don't care whether the wide receiver was nervous. We just care whether his foot came down inside or outside the line.
Counsel, good morning.
Yes.
Just a question, though. This is something that I'm trying to grapple with. Isn't the videotape, though, technically a part of the record? And shouldn't that have been reviewed by the judge?
It was reviewed by the judge, Your Honor. That's a mistake that CDAM made in their brief. It's true that the first motion to suppress, that neither party introduced the video. Instead, at the very end, counsel mentioned this, and the Court of Appeals says this in their opinion. Counsel waits until closing argument and then says, oh, by the way, there's a video if you want to watch it, and the trial court declines at that point. But later on, then the defendant moved for reconsideration, and the trial court admitted the video to decide that, and obviously reviewed it, and the order with which it denied the motion for reconsideration is at pages 67A and 68A of the appendix. And it says that the video largely corroborates Trooper Daniels' testimony, making it clear that the trial court did in fact consider the video. It went on to consider the video at trial, where the video was admitted, and the record makes clear that it watched not only the first 30 minutes, which are the portion that has to do with the traffic stop and the observation of the defendant, but also watched a later portion, specifically at defense counsel's request. That's at 254A to 258A.
So then we would agree then that it's formally a part that ultimately, as an appealable issue, we would agree that's a part of the record.
It is in this case, yes.
Okay, got it.
It is in this case.
Got it.
As I mentioned in the briefs, we take issue with the Court of Appeals seeming to imply that somehow the parties ought to make it part of the record in every case, whether they think it's a good idea or not. I think that infringes on their right to determine what evidence to be introduced. Maybe nobody wants it. This placing of video in a special category in that regard, again, I don't see warranted anywhere in our case law or in the court rule. The last reason...
Mr. Mead, I understand your concern that the Court of Appeals might have overspoken when it implied that there was a de novo standard of review applicable in cases such as this where there's video evidence.
Yes.
That's distinctive, however, from the proposition that what's contained on the video can't go a great way towards satisfying the clear error standard, which you believe continues to be the appropriate standard here. Is that right?
Oh, absolutely, Your Honor. And there's no question. Scott v. Harris, for example, the Supreme Court looked at a video and they said, this video is clear enough that basically if you disagree with it, if the other evidence disagrees with it, if the lower court's findings disagree with it, that is clear error. That's fine. That's what the clear error standard is for. We just don't want to see it taken, not applied to video. There are jurisdictions that don't apply it to video.
So wasn't this at worst a harmless error on the part of the Court of Appeals, identifying there as being a modified standard to the traditional clear error standard? The fact is they looked at it, they saw that what they viewed on the video, they believe that what they viewed on the video went a considerable way toward overcoming and satisfying the proper standard from your perspective, right?
They did, except that when it came to that part of the evidence, they, by their own admission, then weren't applying that standard. They were saying, the question to them was not, does the video render the trial court's findings clearly erroneous, although they may have said that in another part of their opinion, but it appears that it was, what findings do we make from it? And basically they looked at it and they said, we don't think the defendant looks nervous.
I don't know, maybe you can help me, but I don't read the Court of Appeals opinion to have improperly applied a de novo standard at all. I mean, I see that at the end of the facts section they cite to Zahn, and there's a parenthetical characterizing that case as holding that there's no reason to give deference to the trial court when the Court of Appeals is in a better position to assess the evidence. But that's the end of the facts section. And in the analysis section, it repeatedly in a footnote identifies factual findings as clearly erroneous. I mean, I think the Court of Appeals, I guess I don't see why the Chief Justice is wrong, that the Court of Appeals just seems to think that when you have a videotape, in some cases, it's going to make it easier to get to clearly erroneous, right, than it would be in a case where you're reviewing a cold transcript. And obviously, the trial court is in a much better position to have judged how how those words really, came to life in a courtroom, right? When there's a videotape, it's going to sometimes, not always, sometimes make getting to clearly erroneous easier. Is that right? Well,
That's certainly a correct proposition. It certainly can make it easier to get to
right.
that.
So isn't this kind of, this whole case feels a little bit like a solution in search of a problem to me?
Well, there's two problems, at least. One of them is that the court keeps on saying this. There's this record of cases where it says, we don't need to defer. I traced it back in the application for leave, that there's been, 4, 5, 6 cases now where they've said that. And it's sort of creeping in through the back door, saying we don't have to give deference where it's based on video. And even if they go on then to say, yeah, but we find it's clear error, their statements are going to be used and cited and quoted, and it's going to continue to happen. And one thing we'd like from this court is just to make clear, the nature of the evidence doesn't change your standard review. So if you're saying these things and you don't mean we really don't have to give deference, then stop saying them. Or if you do mean that, you're wrong, because we should be giving deference just as we do in any other situation to factual findings. The other problem that I alluded to isn't so much based on the whole question of video review. It's the fact that the Court of Appeals basically discounted one of the things that they found was not contradicted by the record, which is the officer's observation that as the defendant was pulling over, he could be seen making movements as though he were trying to place something on the floor of the vehicle. They mention that fact in a footnote, I think, and say, we didn't see it in the video, but we acknowledge that he could have seen it. So at least they recognize there that video doesn't always show everything. But it never factored into their analysis about whether the officer had reasonable suspicion. And to my mind, at least, that's a huge step toward reasonable suspicion. The idea that a driver would feel the need as he's driving a car, as he's pulling over, to start hiding things. And then it turned out that, bolstering the officer's credibility on that point, at least, that there was contraband found under his seat, the driver's seat, that goes a long way toward reasonable suspicion. Why do you feel the need to impair your driving by doing that when you're being pulled over? Because there's something you don't want an officer to see. As I said in our application, that's not enough for probable cause by itself. But for the lesser standard of reasonable suspicion, it at least ought to be a big contributing factor, and the Court of Appeals never factors it into their analysis. So that's another reason why I believe their decision is wrong.
Mr. Mead, in assessing whether the totality of circumstances in this case rose to the level of satisfying probable cause, is there any aspect at all in your judgment of what the officer was told by his supervisor that should properly come into play? In other words, my understanding of the fact is that the trooper in this case was not aware of what the precise circumstances were that led the supervisor to counsel him to look with some care if he saw this car.
That's correct.
But nonetheless, it seems to me to be a fairly logical inference from that it was prompted upon some sense that there was some possible criminal activity that had arisen here. So my question is, can that be taken into consideration? In other words, in assessing the movements and the nervousness or lack of nervousness and all the other things that the trooper assessed, can they be looked at against the backdrop that there was some sense of criminal activity that might have been attached to this car and driver, or is that inappropriate?
Well, I think the Court of Appeals had it right that at least it didn't factor into the decision on whether the traffic stop itself was valid, obviously. He saw a traffic violation. We all know that you can pull a car over for a traffic violation regardless of what your subjective state of mind is. So it certainly doesn't go to that. But as to whether it goes to reasonable suspicion, I wish the record were clearer on this point, because he was advised by someone from the Metropolitan Enforcement Team up in Grand Rapids. Did the officer know enough from that to know that, oh, Metropolitan Enforcement Team, that probably means drugs? We don't know that. We just know be on the lookout for the car. And is that I'm not sure how that would play into his reasonable suspicion, which
so
is
if I'm inclined to look at the facts of this case indistinguishably from the most random stop, that would be an appropriate way in your judgment of looking at this case?
I think it would be an appropriate way of looking at it in this case.
Okay, that's all. Thank you.
Is that the end buzzer or the?
Nope, you
Oh, okay.
152, it looks like.
Okay. All right. The last reason why we need to clarify this is clear error, and maybe there's not really a dispute on that at this point, I don't know, but is that findings really are seldom based solely on video or documentary evidence. As in this case, they're often based on a combination of testimony and video, or what other courts have called documentary evidence. And so therefore, if it were to be changed, it would essentially be this sort of a bifurcated standard, and in many cases, very difficult, if not impossible, to apply. I mean, the courts say, oh, I can make this finding based on everything before me, the testimony and the video. How do you apply one standard of review to that finding to the extent that it's based on this other kind of evidence, and how do you apply it when it's based on the other? So that was my last point on that. If there are no other questions, I'll stop.
Thank you very much. Mr. Groh?
May it please the court, Daniel Groh on behalf of Mr. Kavanagh. Well, I guess I'll begin my comments with, in light of some of the comments by Chief Justice Markman and Justice McCormick, which I agree with, I will waive my 3 minutes and open immediately to questioning. But I'd also note that there seems to be two primary things that are driving why the prosecutors brought the appeal here. First is the need not rely on language in the statement of facts at the beginning of the Court of Appeals opinion. I think it may have been more appropriate for the Court of Appeals to say, need not rely on in this case, or in light of our analysis below, that those words were absent from that sentence might have raised some concerns on behalf of the prosecutor, but I don't think it changes the overall analysis whatsoever. The other thing that seems to be a concern to the prosecution in this case is the should consider language with regard to whether or not the court should be inclined to receive video evidence or inclined not to receive video evidence. And this court might consider there might be a court somewhere in the state of Michigan that might say, well, you know, we've gotten along without video evidence for a long time. We don't need video evidence. And I think what's important about this language in the Court of Appeals opinion is that there should be a bias in favor of receiving evidence, such as video evidence, rather than a bias against receiving it. And my only concern with whatever this court does with regard to this application is I wouldn't want this court to send a message back to trial courts that if you don't receive evidence like video evidence, that's okay. You can do whatever you want. Because I think it's important to the citizens of the state of Michigan that the Court of Appeals or any reviewing court has every opportunity to receive all the evidence and that the trial courts don't create an atmosphere where a criminal defense attorney might feel afraid to present video evidence or be intimidated by the court. So I hope this court...
We're not here to decide, like, you don't expect that, you don't want us to issue an opinion saying trial courts have to always take videotapes, right? We're not.
No.
We have a system of party-presented litigation. We let the parties, there may be occasions where the parties don't want to introduce a video, and you don't need us to meddle with those decisions, do you?
I agree completely.
Okay. And do you also agree that we might have a solution in search of a problem here? I mean, why?
I do agree.
Isn't opposing counsel correct that there's all different kinds of evidence, and in many cases there might be a videotape, and there will also be testimony, and there might also be an audio tape, and why would we parse different standards of review for each of those different types of evidence? Is there any?
I agree completely, and I don't think the Court of Appeals departed from that standard, frankly.
Okay.
Mr. Groh, focusing further on the substantive issue here, whether there was sufficient probable cause, the trial court, to the best of my understanding, made a number of factual findings. That defendant was extremely nervous, that he had engaged in furtive movements, that the defendant and his female passenger had provided different answers concerning where the two persons stayed, how they spent their time in Grand Rapids, the status of their relationship with one another. The trial court also found that the trooper, in his judgment, was credible. Are there any of these particular findings, with the possible exception of the nervousness, that you find to have been clearly erroneous determinations on the trial court's part?
I do, and I agree with the Court of Appeals at page 7 that said the core problem essentially is that there was a failure of the officer to articulate specific inferences of possible criminal activity. And take, for example, if you're traveling in a state that you're not familiar with and you stayed at a hotel that has an ambiguous or general name like the Travel Lodge or Vacation Lodge or Lodge Retreat, to the extent that the passengers of the vehicle articulate slightly different versions of the same name, or in this case, if the driver says, well, yeah, the receipt's in the car, I mean, if that's important.
Isn't it the cumulative problem, though, that really was what was focused upon by the trial court, that there are 3 or 4 different discrepancies in the answers that were provided by the defendant and his girlfriend or whatever the relationship was?
I think that's the way the trial court certainly looked at it, but I think in light of some of the significant inconsistencies between the video evidence and what the trial court described or what the officer described, I think you have a situation where the due regard to be given on as to those credibility and making more of insignificant differences becomes like, what are we really talking about here? I think once the air starts leaking out of the balloon, it can release quickly, if you know what I mean. And if there's not further questions, the last thing I'd like to emphasize is that I'm very concerned in general about excusing conflicting evidence or extrinsic evidence that makes a conclusion troublesome is by simply calling it a credibility determination. That's the one thing that when I read these cases that I find a bit troubling, and I don't think the court's going to rule that way in this particular case. But again, I'm very comfortable with the Court of Appeals opinion here, as well as my briefs, and again, if there's any other questions, I'd be happy to assist the court.
Okay, thank you, counsel.
Thank you.
Case will be submitted.